Hello, I'm Adrian Lifely. I've worked as a commercial disputes lawyer in London for 30 years and I'm an accredited mediator. I'm shooting this video to give you a heads up about the Singapore Mediation Convention. In full, it's called the Convention on the Enforcement of International Settlement Agreements Resulting from Mediation. As that's a long title, I will just call it the Singapore Mediation Convention. These are the key points you need to know about the Singapore Mediation Convention, therefore. First, it's not yet in force. It's due to be signed on the 1st of August 2019, and it will come into force once 3 countries have ratified it. Second, the purpose of the Singapore Mediation Convention is to promote the use of mediation in order to resolve international commercial disputes. It will do it in 2 ways. It contains a model law on mediation with the intention that countries that don't already have a system of mediation law will implement one based on the model law. This is really important as parties cannot be expected to mediate if mediation does not have a legal status with safeguards built in like confidentiality and the independence of mediators. The second element of the Singapore Mediation Convention is an international system for enforcing settlement agreements reached after commercial mediation. This needs a little explanation. There are international conventions for enforcing court judgments and arbitration awards overseas, but there is no convention for enforcing settlement agreements where there hasn't been any litigation or arbitration. The convention therefore plugs that gap, giving the parties the means to enforce settlement agreements. But in order to understand the convention, it's really key for you to note 2 things. Firstly, that the Singapore Mediation Convention, as the name suggests, only applies where there has been a settlement reached after a mediation. Therefore, you can't invoke the Singapore Mediation Convention if there hasn't been a mediation. The second thing to note is that the Singapore Mediation Convention only applies to commercial disputes between international parties. It does not therefore apply to a settlement of, say, an employment dispute or of a commercial dispute between 2 UK companies, even if there has been a mediation. As you can probably guess, the intention is that with the ability to easily enforce settlement agreements reached after mediation, this will increase the use of mediation in relation to international commercial disputes. Now that you know the Singapore Mediation Convention is coming, I invite you to view my next 2-minute video in this series called Singapore Mediation Convention Part 2, which will tackle issues relating to the enforcement system. As always, please take specific legal advice before you take any decisions.